So let's start with causation and remoteness. Yeah. Negligence is the breach of duty of care owed by the defendant to the claimant, which results in damage to the claimant that is not too remote. We already have a revision session done on duty of care and breach of duty. I'll send that to you and you can revise. But just to remind you, duty of care can be established in certain situations that is already recognized in case law. For example, doctors usually owe duty of care to their patients. If they breach that duty of care and causation and remoteness is also established, then negligence claim should succeed. So this is how you should approach a problem question on negligence. First of all, you need to establish a duty of care. Then you need to show the breach of duty. You should show that the conduct by the defendant fell below the standard of care, apply the standard of care test, and finally you need to apply the test for causation, factual and legal causation, and discuss if the outcome is too remote from the breach. Even if the causation is established, there are scenarios when, because the breach is too remote from the result, the negligence claim fails on remoteness. So all the four elements should be discussed in a negligence problem question. Yeah. The causation has two main questions that you need to answer. Was the defendant's breach of duty of care or other tortious intervention a factual cause of the damage? And is the damage attributable to the defendant's breach of duty? So those two questions have to be answered affirmatively in order for causation to be successful. There's a but-for test for the factual causation. The breach of duty must be the factual cause of the damage. The general test used by the court to determine factual causation is known as but-for test. You can cite the case of Cork versus Kirby-McLean. Lord Denning stated, if the damage would not have happened but for a particular fault, then that fault is the cause of the damage. If it would have happened just the same fault or no fault, the fault is not the cause of the damage. So you need to think about if the damage that happened, the result that came out, is directly attributable to the defendant's breach of duty of care. Like, if the defendant didn't do what he did, would the damage still happen or not? That's the main question as per Lord Denning's guidance. And that's the main test you need to apply for establishing factual causation. It looks like it's a straightforward test, but it's not always like that. We have some complicated cases where it's not that easy to apply this test. So we have to have a look at these three possible scenarios: lost chance of recovery, avoiding injury, multiple causes of damage, multiple consecutive causes of damage. So these are the three scenarios that often come up, and it can be quite problematic to establish causation in these kind of scenarios. Lost chance of recovery, avoiding injury. This basically means that if a claimant cannot establish that but for the defendant actions, they would not have suffered loss, they may attempt to argue that the defendant's breach has lowered their chances of a more desirable outcome. So even if it was not completely defendant's fault what happened, it has certainly worsened the outcome. That's basically what it means, lost chance. So if it was not for the defendant, what happened wouldn't have been that bad. And you can see the case about lost chance of recovery. Greg versus Scott, this is interlinked. I'm going to send you the slides and you can click on this link and see the case summary on our website. The second kind of scenario where it will be hard to establish a factual causation would be multiple causes of damage. So this is when there are multiple causes that many things happened, and all of these things that happen could have something to do with the outcome, with the result. So it's hard to say that it was defendant's fault completely, the outcome. And then the third scenario is a similar thing. And in this kind of circumstances, we should have a look at the appropriate test and cases. So you just need to identify a relevant case, apply it to the facts of the case, and say what would be the most likely outcome. Obviously, you will never be able to say for sure if the court in this case, in the problem question scenario they give you in the exam, will say that, you know, causation is set out or not. All you have to do in answering a problem question is identify the relevant law, discuss the relevant rules, apply to the facts of the case, and say what would be the most likely outcome. You cannot answer the question for sure. You just have to identify all possible answers. Fairchild test is very important that you remember. In Fairchild, in this case, the claimant had been exposed to asbestos dust by more than one employer in different periods of employment. All of them developed cancer, and it was impossible for the cause of death to be attributed to any single employer on balance of probabilities. Right, and then House of Lords held that appropriate test was the test established in the previous case, Maggie, whether the defendant had materially increased the risk of harm towards the claimant. Therefore, the employers were jointly and severally liable. So as long as the risk was materially increased because of the defendant's conduct, then as per the Fairchild test, the negligence liability will be found. So it doesn't have to be completely the defendant's fault what happened, but defendant's conduct has increased the risk of the harm to the claimant. So that's basically what Fairchild test is. And there are few parts of the judgment, that a few principles that came out of this case that you should remember when applying the causation test. In certain circumstances, a claim is not defeated by the impossibility of proving that the breach of duty caused the injury suffered. Proof of causation must be impossible for the claimant to benefit from this exceptional approach. So this only applies if the proof of causation is impossible. So only that's like a last resort. The House of Lords in Fairchild clearly noted that proof of material contribution to a risk of injury is not the same as proof of material contribution to the injury itself, particularly in the case of non-progressive disease. Therefore, the test is more flexible. It does not have to be proven that the material contribution was to the disease itself, to the injury itself. In this case, it was cancer. Just the risk. So because here the employers did something that increased the risk of cancer, they were liable. So they did not have to prove that what the employers did actually contributed to the cause of cancer, just the risk, which makes the test more easier to satisfy on the balance of probabilities. However, their lordships accepted that as a matter of law, in certain circumstances, proof of contribution to the risk will be sufficient evidence of causation. On balance of probability, so the standard of proof to be applied in negligence and in all civil cases has to be balance of probabilities. Therefore, we should say in the problem question, when answering a question on negligence, if all the balance of probabilities, negligence claim would succeed in the given circumstances. Now let's consider also remoteness principles. Here, remoteness requires defendant's breach of a legal duty to cause claimants damage. the court may decide that it would not be appropriate to hold the defendant liable for the damage as the injury was of an unexpected type. As a result, the court may hold that the damage is too remote. This is basically to control the floodgates of liability. So if something unexpected happened, and if all the elements of negligence is satisfied, there is a safety net for the court to say that it was unexpected what happened, and even though all the elements of negligence are satisfied, it's just too remote to attribute to the defendant's conduct. And this kind of controls the floodgates of liability. When you're applying the remoteness test, you should cite the relevant authorities and principles. For example, the correct test for remoteness is reasonable foreseeability. The foreseeability is key here. You should show to the examiner in a problem question or essay question that foreseeability is established. You can cite the case of Wagon-Mount, which is an accepted authority for foreseeability question on remoteness. And you could also consider the case of BPE solicitors and another. Here, in this case, the principle that loss must be foreseeable is dependent upon the scope of the duty of care. If the particular kind of damage suffered by the claimant falls outside the scope of the defendant's duty, then it will not be considered to be within a reasonable contemplation of the defendant, even if it was foreseeable. So foreseeability is not the only consideration. We should also consider that the duty of care was definitely there. So all the elements plus the foreseeability, which is the key consideration for remoteness. Vulnerability eggshell skull rule is something to remember for remoteness requirement. If the type of injury is foreseeable, but the result that happened was unusual because of particular vulnerability of the victim, of the claimant, then defendant still remains liable for all losses because the defendant has to take the victim as he finds him, which is the eggshell skull rule. You should remember this case for eggshell skull rule, Smith versus Leach, Brain and Co. Here, the claimant was splashed by molten metal as a result of his employer's negligence and suffered a lip burn. This burn triggered a cancer, and claimant died. Claimant's lip was a pre-malignant at the time of the accident. So this was an unusual outcome. It shouldn't have happened, but because of particular vulnerability of this person, that's why the cancer was caused. The court had to consider the foreseeability if this was foreseeable damage. It was held that some form of harm from the burn was foreseeable, although the particular burn that this person got in these circumstances was not foreseeable. Despite the fact that death from cancer was not a foreseeable consequence of the burn, defendants still remain liable in negligence for the full extent of the damage because of the eggshell skull rule, even though it was not. Even though the particular outcome shouldn't have happened to a normal person, and this claimant here was particularly vulnerable, defendant still remain liable because defendant has to take the claimant as he finds him. We have eggshell skull rule in criminal law as well and tort law. Now, I'd like to show you how you should do your legal research on our website. This tool makes it a lot easier for you to find information you're looking for. You could use our search bar at the top of the website to find cases as well as notes on a particular topic. You just have to choose a keyword that you need information about. For example, if you have a problem question about duty of care or causation, you can just put duty of care in the search bar and you will see everything we have on duty of care. Similarly, if you need to find cases on causation, just put causation there and you find all the cases, all the notes we have about causation. So make sure that you use our search tool to save lots of time on legal research. Now I'd like to say a few words about how SimpleStudying can help you to achieve your desired grades. And after that, you can ask me any questions you may have on this causation and remoteness or anything else about tort law. At SimpleStudying, our content creators and tutors are law graduates who have achieved first class or high 2-1 grades in their exams in law, and they have experience with tutoring, and we can help you achieve your high grades, as well as our SimpleStudy resources are helping you to get high grades in the simplest way possible. All our content is designed from our experience to give you just the right information, what you need to know, insider tips to achieve your full potential on your exams. You can read our notes and case summaries on Tort Law on our website. We also have tutorial videos, example essays, has been awarded high grades, quizzes, flashcards, exam tips. You can have a look at these links. Also, I suggest you have a look at our tutoring services. Other than this kind of webinars, group revision sessions, we also have one-to-one meetings with students where a tutor will be assigned to you, and tutor will help you achieve your desired grades. We can help you prepare for your exams. We can review your assignments, give you feedback, guide you at every step, and be with you until you achieve the desired grades, and most likely a first class if you follow our techniques. We have already helped thousands of law students to get high grades. 90% of our regular users get a first class. If you have our subscription to our services, use our materials to study every day, as well as a few tutoring sessions, at least 6 tutoring sessions, you should be able to get a first class. If you would like to get high grades, please join SimpleStudying now. Thank you very much.